Right off the bat, we're in session. Case 243391. This number may sound random, but for Miss Buford, it's about to carry some serious consequences. Buckle up, because what starts as a simple violation hearing spirals fast.
All right, we're on record again. This is 243391. Oh, still trying to be out of probation stuff.
Wait, man, you can't go.
All right, the warrants will be recalled.
Violations of the gate. Discussions with my client and discussions before. Foreign and flout.
Why did you catch that? Judges don't usually comment on attitude unless the vibe in the courtroom is already tense. This is the first red flag that the defendant's courtroom behavior is about to play a starring role.
Further, she has the right to have a hearing this matter. And she understands the allegations. She has to show cause Mr. Orders away to her guarantee guilty to that her 771 to the 2 months period now passed. That would be closed successfully, balanced with fines and costs and
Did you understand all that? Yes. All right, Miss Buford, don't come up here with that attitude. Just shrug it off. Listen, ma'am, you understand you're here today for a violation of your probation? Then yes? Yes, ma'am. All right, you understand there's an allegation that you failed to appear for your orders on your probation? Yes. I have the recommendation on one of the actual violations. So knowing all of that, ma'am, how do you plead to the allegation you failed to appear for your orders appointment on 4/4/25 and 4/14/25? Is anyone for She posted a payment, and it should have been applied to the other case, and it was applied as cash bond on this case. Yeah, it should have been applied on.
Another trial, I'm not sure. You should go apply.
Yeah, the Tuesday. No, see that she's on it.
Fire here's the turning point. The judge isn't just talking about missed appointments. He's talking about disrespect. In courtroom terms, this is a huge deal. Judges can and will escalate punishment when they feel their authority is challenged. And at just 22 years old, Buford is learning that the hard way.
So you're keeping that status, closing the probation. I'm allowing you to keep that status. But you're, the way you behave in court, so egregious. You know, like, you're grown. How old are you? 22 years old. You cannot come into places. Court, the one place in the world I can put you in jail. The one place you can't come into screaming, yelling, screaming the F word at people, here. You can't do that. Are you confused by that?
Honestly, I am a little confused by it because I was with my mother and I don't cuss in front of my mother. So I didn't scream any words, so I didn't say disrespect, like she was saying,
you weren't disrespecting me.
No.
Why do I court officers come out? And why do all the notes in the file on January 3rd, called up to the court, this is another staff member. This is just another random staff member in the building writing a note. Very, very versatile.
Think about this. Multiple staff members on different days, all logging complaints about the same behavior. Bookmark tabs, that's not just bad luck. That's a pattern. And when a defendant builds a paper trail like this, it becomes nearly impossible to argue it's just a misunderstanding.
Staff screaming in my ear about her ticket, wants to know why she has a felony, would not let me talk. These are the ROA notes. Then you cancel your appointment twice. My probation department advised me that, you and Kelsey, I worked with Miss Havner. She had to hang up the phone because of your behavior. And then after that, you called back again and you spoke with the clerk in the probation department. I didn't know anything about the case. And you were screaming at her too. I've got notes from so many different clerks in this file. Asked what I can help her with. She began screaming at me. She wanted to talk to the supervisor. I tried to transfer, but she refused to talk to her. I had to terminate the call because she continued screaming and using profanities and would not let me. I mean, it's like there's note after note after note. I know that they had to call the court officers, the probation department, because your behavior on probation yesterday, demanding that I see you forthwith. I have documents. You were on it at 1. And then you chose not to come back at 1. And it's like, this is a minor, overall offense. I mean, I know that because I sentenced you immediately from the bench. Gave you non-reporting probation. All you had to do was come in and do your orders from this Havner, not pick up any new cases. You can't do it. You missed that appointment 2 times. It's a lack of self-control. Everyone here is a bad guy. So your payment plan continues on the driving while license suspended and the civil infractions for expired plate that you have. On this case, I'm closing the file. You will keep your versionary status. You've got no prior criminal history. You're young. I don't want to.
Collision boom. 5 days in jail, effective immediately. Notice how the judge balances fairness with discipline, waiving fees but still enforcing jail time. It's a classic example of judicial discretion, sending a message that respect in court isn't optional.
I don't know, even though it seems like you want that on your record. I'll waive the balance. You're doing 5 days jail for Ma'am, an appeal to circuit court may be taken within 21 days of the date of sentence or is permitted pursuant to NCR. Step 25B. If the sentence includes incarceration and you wish to file an appeal but are financially unable to obtain a lawyer, the court will appoint the lawyer to represent you on the appeal. Keep the request of the lawyer made within 14 days of the date of sentence.
This final moment hits different. The mother's reaction says it all. Shock, fear, maybe even disappointment. And the judge's parting words? I see where she learned it. That's not just a legal judgment. It's a personal one. And it lands heavy.
No, because she has anything she needs to give you. She can hand it to the court office. Ma'am, I see where she left it.